Welcome back to Tipping Point. I'm your host, Kara McKinney. The amnesia of James Comey, Hillary Clinton, Dr. Anthony Fauci must be contagious. You know what I'm talking about. The bad case of selective memory loss each suffers from whenever they have to go under oath. With all the times they claim not to recall important details surrounding their life and work, maybe we should call special counsel Robert Hur over to see if they have the same poor memory that Hur diagnosed Biden with. And while we're at it, let's add in a checkup for Nathan Wade's former law partner and divorce attorney too. Terrence Bradley was the latest to be forced to testify in the romantic saga that is Fulton County, Georgia DA Fani Willis and her special prosecutor Nathan Wade. The judge in the case, who did donate one time to the Willis campaign, is tasked with deciding if the pair should be tossed off the case on ethical grounds. The allegation is that the pair were romantically involved before the RICO case against President Trump was launched, and that Willis appointed her former lover to his position, allowing her to receive gifts and travel from him, with the money being paid from her office, courtesy of the taxpayer. Those are obviously allegations that the pair vehemently deny. They claim their relationship turned romantic in 2022 after joining the case together, despite newly obtained cell phone data we covered just last week, reportedly showing the pair meeting up late at night at Fanny's house for some late-night work that just so happened to last from around midnight into the early morning hours of 4 or 5 a.m. Well, now that Bradley has to be the one testifying, he's claiming that he doesn't know anything. Very convenient, especially when he had previously texted to one of the lawyers representing a co-defendant of President Trump's that Fani and Wade had started their romantic relationship years before opening the Trump RICO case. Maybe he spilled the beans when he didn't realize how much it would hurt the pair, because now that he was asked about it on the stand, Bradley says he was just speculating and that he doesn't actually recall when the relationship started or any pertinent details about it. While on the stand, Bradley was also pressed about the time he had also responded, looks good, to a filing made back in January by that same lawyer, which included parts of Bradley's previous testimony on the Wade-Willis love affair. He now says a stamp of approval only had to do with financial information listed in the message. Joining us now to discuss is criminal defense attorney David Gelman. David, thanks for being here tonight.
Hey, thanks for having me, Kara.
Great. So what do you make of Terrence Bradley now claiming not to know anything about what he had previously asserted so confidently?
Mr. Bradley, he is going to have some issues. That's what I can tell you that. You know, I tell people this. Don't even think about the words that are coming out of their mouths, right? In fact, if you were going to just look at the actions and how Mr. Bradley was acting yesterday, turn down the volume to the TV. How would you describe him? Would you trust what he was saying? You know, most likely, probably not. I mean, the guy was sweating profusely. He was looking down. He would barely made eye contact. You know, you have to look at the demeanor of these individuals. Now, take all that out of context and now put in the words. He admitted on the stand multiple times to the different attorneys that, yes, I lied. He pretty much said that. He said, well, okay, I guess you're right. This did not happen, or this did not happen. I said this when it really is this. He flat out ethically lied. Now, I want you to also understand this, Kara, and to all your listeners. The judge knows exactly what Mr. Bradley was going to say or not say, because they had a closed door in-camera hearing, if you will, prior to all this happening. So the judge knew what he is allowed to say or is not going to say, because attorney-client privilege is pretty much the most important privilege that a attorney can have. You know, when I speak with a client, I cannot disclose anything that the client says to me, as important or unimportant as it may be, to get the trust of the client. So when you do not have the trust of that client, you are screwed as the attorney, pretty much, in legal terms, if you will.
Very legal terms. But you're right. I know the judge also was reportedly kind of taking note every time we heard from Mr. Bradley saying don't recall, don't remember. And like you said, on the stuff that he did remember, and it's in writing, he now says, well, I was just speculating. I didn't really mean it. And then the lawyers would say, what do you mean you didn't mean it? Well, why'd you say it then? So it seems very clear, at least from the attorneys representing the Trump co-defendant here, Mike Roman, that it just seems more that Bradley doesn't want to say. Not that he doesn't remember, that he just doesn't want to say, because it's not going to look too good. And like going back to your point, the judge, it seems, was taking note of how many times Mr. Bradley was saying, don't recall. Strange to be the divorce attorney and yet not know anything about the relationship at hand. So very strange, right? But there are some breaking updates that you brought to my attention as we are now coming here and doing this interview, but it has to do with a different case also concerning President Trump. So leaving Georgia for a second, going up to New York, we saw Judge Engoron hand down that horrific decision against President Trump. He's actively trying to appeal it right now, but the New York appeals judge is looking at President Trump and his motion to pay about $100 million of the $454 million judgment. That's how it is at this point. This is where it stands. He wants to pay about $100 million of that, but the appeals court is denying him on that. What do we know about the situation so far?
So it's very interesting, and I'm kind of surprised the appeals court is denying the motion. The appeals court is saying that President Trump has to pay the full amount, $460-something million, which is the amount owed plus a judgment, or plus the interest, I'm sorry, and which all goes into an escrow account to the state of New York. President Trump has offered to pay $100 million, and that is a cash offer. So we're not talking about a couple, $1 million here. The judge also is allowing President Trump and Donald Trump Jr. and Eric Trump to continue to operate the businesses in New York City, in New York State, I'm sorry. Now, under Erdogan, he said that they were not allowed to operate them. So that is, I guess, throwing them a bone, if you will. But I'm very surprised that the judge would not allow for President Trump to stay, if you will, the remaining balance of the judgment. I don't understand why, because the amount of money is not going to an individual. It's going to just the state of New York, or really an escrow account, pending the appeal process. So why is he not, or why are the judges not doing this? Is it for political reasons? Is it to make Donald Trump look bad? Probably all of the above. I would assume what the president's legal team is going to do now is going to appeal the appellate division's ruling to a higher court and, appeal this. Because if you think about it, who has $400-something million liquid? Elon Musk, the richest man alive, doesn't have that. So Donald Trump, even though he is a billionaire, a lot of his money is tied up in stocks and real estate, just like multiple other billionaires. So I find it very unfair to what they're doing. He is making a good faith effort to pay the amount of money, putting up $100 million. Why are you not agreeing to a stay for the remaining amount? Doesn't make sense.
It really doesn't. And one thing that I've learned through this process is I didn't realize how expensive appeals were, right? I didn't realize they have to come up with the money that was ruled against you and then tack on more on top of that, some interest, and then put that in the escrow account, as you were saying, while the appeals go forward. And that just shows how they want the process to hurt and to punish President Trump, even if it all works out for him in the end, even if he's able to fight off all these biased liberal court hacks. I mean, they still made it hurt for as long as possible during a sensitive time on the campaign. So that's one of my takeaways, is how they weaponize and use the judicial system against those that they don't like. But David, I appreciate your insights. Thanks for joining us tonight.
Thank you for having me.